The crisis has come. Think judicial activism is a new thing? Well, think again, because that was the warning we got from John Taylor of Caroline over 2 centuries ago. He wrote an entire book smacking down Chief Justice John Marshall, who followed Alexander Hamilton's playbook, basically redefining words like necessary and proper in order to justify a national bank. Taylor called this construction, and he saw a catastrophe coming. But he wasn't just a critic, he was prophetic. Today, we call it legislating from the bench. Taylor understood it for what it was: judges rewriting the Constitution to justify unlimited power. I've got all the juicy details next. But first of all, before getting to that, welcome. And thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, July 23rd, 2025. To kick it off, let's go back to 1819. The Supreme Court just handed down its opinion, maybe one of the most famous ones in history, McCulloch versus Maryland. Now, on the surface, it was basically about whether or not states could tax a national bank. But Taylor was concerned about what he thought was really happening under the hood. That is, the Supreme Court had justified a national bank, which was not a power expressly delegated to the federal government in the Constitution, by redefining terms. And so Taylor responded by publishing one of his most important and, well, almost totally ignored and forgotten books called Construction Construed and Constitutions Vindicated. And here from right from the opening, basically, he gets right to it. That gigantic institution, the Bank of the United States, has been justified by the Supreme Court of the United States on principles so bold and alarming that no man who loves the Constitution can fold his arms in apathy upon the subject. And Taylor understood that once you break the limits of the Constitution to justify one power, whether it's for a bank or for anything else, you've broken the entire system completely. And here's how he put it. Those principles, so boldly uttered from the highest judicial tribunal in the United States, are calculated to give the tone to an acquiescent people, to change the whole face of our government, and to generate 1,000 measures which the framers of the Constitution never anticipated. It makes me think of Patrick Henry's really incredible warning, like jaw-dropping prediction near the end of the Virginia Ratifying Convention in the summer of 1788. He said, if you guys go with this, you're going to end up with 10,000 implied powers. 10,000. Now, here we are by 1820, and Taylor's basically saying, what they're doing, you're going to get 1,000 measures, so probably on the way towards that 10,000. So next up, how they pulled it off. And first, the weapon. We already named it, and it's called construction. Now, for Taylor, construction meant constitutional interpretation, but you could have a good reading of the Constitution or a bad construction, because it's not all created equal. One approach is honest, the other one is manipulative. And here's how he put it. There are 2 kinds of construction. One calculated to maintain, the other to corrupt or destroy the principles upon which governments are established. And here's how you tell the difference. Either get common sense versus academic-style legal jargon, really, is the way to put it. He said one is visible to common sense, the other consisting of filaments so slender as not to be seen except through some magnifying glass. One which addresses the understanding, the other which addresses prejudice or self-interest. Now, to understand the construction that Taylor was really railing against when he published this in 1820, we have to take a little side quest going back to 1791 and the first bank, Alexander Hamilton's brainchild, just a few years right out of the gates, really, just a couple of years after the Constitution went into effect. And he needed to justify his national bank to further his economic plan. But the problem was, a power to establish a bank was not something expressly delegated in the Constitution. So his solution, well, redefine words in the English language. He basically redefined the word necessary to mean, in essence, convenient. So necessary no longer meant necessary to Hamilton. It meant what is convenient or conducive or useful. And that's how he put it in February of 1791. Necessary often means no more than needful, requisite, incidental, useful, or conducive to. It is a common mode of expression to say that it is necessary for a government or a person to do this thing or that thing, when nothing more is intended or understood than that the interests of the government or person require or will be promoted by the doing of this thing or that thing. Now, we know that there's been studies of the use of the word necessary from the time of the founding, and Hamilton's version of this definition was nonsensical. No one understood the word necessary as meaning anything other than, well, necessary. In response, Thomas Jefferson wasn't buying it at all. He said, "It has been much urged that a bank will give great facility or convenience in the collection of taxes. Suppose this were true." So Jefferson's basically taking the position that, okay, maybe it is going to be more convenient to collect taxes. He wasn't even debating that. He's talking about the constitutionality. In fact, that was the title of his essay, Opinion on the Constitutionality of the Bank Bill. This was February 15th, 1791, 10 months to the day before ratification of the Bill of Rights. Kind of an important time. But he said, suppose this were true. Yet the Constitution allows only the means which are necessary, not those which are merely convenient for effecting the enumerated powers. And Jefferson understood where Hamilton's word game would lead. Basically, it would open up a can of worms for unlimited power. He said, if such a latitude of construction be allowed to this phrase as to give any non-enumerated power, it will go to everyone. For there is no one which ingenuity may not torture into a convenience in some way or other, to some one of so long a list of enumerated powers. So if you approach this instead of being something that's necessary to carry out the enumerated powers, but just merely convenient, it doesn't take a lot of ingenuity to come up with basically anything and everything is convenient to this. And therefore, what he said is you're going to reduce you can get rid of the entire Constitution. Just keep the necessary and proper clause, and that's all you need, basically. He said it would swallow up all the delegated powers and reduce the whole to one phrase as before observed. Now, it wasn't just Jefferson who was hammering on this Hamiltonian twisting of the meaning of the word necessary. Also, Edmund Randolph and others. And I covered that in some detail, that total takedown in detail, the 1791, in another episode a few months ago, Necessary and Proper, the big lie that unleashed big government. So let's fast forward back to our main quest, 1819, McCulloch versus Maryland. Chief Justice John Marshall decided to ignore people like Attorney General Edmund Randolph, Attorney General under Washington, Thomas Jefferson, and instead he adopted Hamilton's definition of necessary as, in essence, convenient. And in some places, he took the Hamiltonian view almost word for word. Now, here's the money shot where he redefines necessary. We find that it frequently imports no more than that one thing is convenient or useful or essential to another. And that brings us back to John Taylor of Caroline. And he saw exactly what Marshall was pulling off here. Linguistic fraud in broad daylight. He swapped words in the Constitution, necessary for convenient. And what do you get with that? Taylor said, but this interpolation of the words convenient, useful, and essential into the Constitution is, in my view, not even a plausible argument. It is merely a tautology of the phrase necessary and proper, but excluding the restriction attached to the latter. Again, if you want all the details on the various views of the necessary and proper clause, including from one of the people who drafted it, that's Edmund Randolph. Make sure you check out that episode. That'll be linked to in the show notes. I'll get to that in just a moment as well. Like Jefferson did years before him, Taylor also explained that once you accept this word game as constitutional, words mean what the Supreme Court say they mean until the Supreme Court changes its mind, you've basically destroyed all constitutional limits. He wrote, in short, if the argument of convenience be sufficient to establish the constitutionality of the law in the case of the banks, every power whatsoever delegated to Congress may reward its coadjutors with exclusive privileges and embrace within its means monopolies of every description. And here's what made Taylor's warning so brutal, so devastating. This wasn't some new legal approach that the court invented here in 1819. It was the exact same kind of trick that the British used throughout the Revolution or leading up to the War for Independence to the American colonists. And Taylor understood this as well. He said previously to our Revolutionary War, the colonies had been thoroughly lectured upon the subjects of sovereignty, supremacy, and a division of powers. The English Parliament, he wrote, the English Parliament contended that its sovereignty or supremacy included all means necessary or convenient, in its own opinion, to effect its ends. So if government gets to determine what's convenient to be able to carry out whatever power it's authorized to carry out, you're going to have unlimited power. That was a big part of the foundation of the resistance that led to the War for Independence. Because if government determines what government's limits are, well, those limits are not going to last long at all. Now, I realize I'm running through a lot of really detailed and important historical information pretty quickly here, but it's my hope that this episode serves as a bit of a highlight reel for you. And if you're the type of person who hears this information and wants to, consume all the info possible on this, well, you're in luck because the TAC has you covered. After every single episode, we publish a blog post for that episode. Alan Mosley does an awesome job, very consistent, just on top of it, getting it organized. I get it published a couple of hours after the show is done, the live stream is over at 10thamendmentcenter.com/path to liberty. And not only will Alan have all the various platforms we're on, both video and audio platforms, but just below that, there will be a show links section. And as long as I did a decent job organizing my outline, which I'll pass off to him after the show's over, then he's going to include all the links that I'm mentioning for the episode, generally in order that I cover them in the show. Now, there's not going to be a ton of links in this one. Primarily, I'm going to encourage you to read. You'll get a free download of John Taylor's full book. Plus, you're going to have opinions from Alexander Hamilton, Thomas Jefferson. I also have that other episode on the necessary and proper clause, plus a bunch of other stuff as we go through the rest of the show here today. Again, that blog post will be published a couple of hours after the live stream is done. 10thamendmentcenter.com/path to liberty. But let's get back to it because this brings us to the next important step, the heist, stealing sovereignty. For the founding generation, sovereignty meant final authority. It was always in the hands of a single dude like a king, maybe a queen, or under the British system, they also had the king and parliament. In essence, they could do no wrong. That was their attitude. And that was a real foundational principle underlying the American Revolution, which led, of course, to the War for Independence. Now, here's the key point for Taylor, for Jefferson, and many others. In the American system, under the American constitutions, and I say that plural on purpose, no government is sovereign. None. Zero. Not states, not local, not federal, none. Even if you want to call it a national government, that's not sovereign. At least it's not supposed to be. And here's how Taylor put it. Neither the Declaration of Independence, nor the federal constitution, nor the constitution of any single state uses this equivocal and illimitable word. And that's a tough one to read. He said, in none is there the least intimation of a sovereign power. And in all, conventional powers are divided, limited, and restrained. So if someone is sovereign, or if an entity is sovereign, it has final authority. There really are no limits to its power. And so Taylor is very concerned about the use of government sovereignty terms. And he understood just why the framers were so careful to avoid using that kind of power or that kind of language in the Constitution, because under the American system, government is merely an agent of the people of the several states. All power flows from the people to government, as James Wilson put it. So our constitutions are superior to our governments, because those are the rules for governments. So the people are superior to the constitutions. That's a very kind of easy food chain. Government is at the bottom. They're just an agent or servant. The Constitution is above them. That's the supreme law of the land. That's the rules that they are supposed to follow. And then the people have final authority or sovereignty, the people of the several states. And if you use the term sovereignty to describe a government, then government isn't a servant. And even if you said it had sovereignty in particular spheres, that's how John Marshall described it, then it still also has final authority in those spheres. You've stolen that sovereignty from the people of the several states. And Taylor described it like this: the language of all these sacred civil authorities is carefully chastened of a word at discord with their purpose of imposing restrictions on governments by the natural right of mankind to establish societies for themselves. It could not be correctly used as a vehicle of power, either external or internal. Why? Well, because the idea of investing servants with sovereignty is absurd. That's how he put it. The idea of investing servants with sovereignty and that of investing ourselves with a sovereignty over other nations were equally preposterous. So what did John Marshall do with this foundation that pretty much everyone understood, even if they all didn't like it? Well, he decided to ignore it totally. Here he is in McCulloch. The creation of a corporation, it is said, appertains to sovereignty. This is admitted. So for John Marshall, he knew that there was no expressly delegated power to either create a corporation or to establish a national bank. He had to find that power elsewhere. And he's making the case that it is necessary and proper, convenient to carrying out one of the other powers, like collecting taxes. And it's only necessary and proper because it is part of an act of a sovereign. Going a little further, but to what portion of sovereignty does it appertain? Does it belong to one more than to another? And so, of course, the question before the court was basically whether or not Maryland could tax the national bank, which was a tool or basically an engine of the federal government. And he's saying, well, in America, the powers of sovereignty are divided between the government of the Union and those of the states. Totally different from how Taylor was describing it. They are each, he said, sovereign with respect to the objects committed to it, and neither sovereign with respect to the objects committed to the other. So then Taylor responded to this specifically, and he pointed out that if the federal government has even a portion of sovereignty, Marshall repeatedly called it spheres. Even if they had a portion of sovereignty, then the people of the several states don't have sovereignty, because either you have final authority or you don't. Then he wrote, by contending that the federal government created in virtue of their retained and inherent sovereignty, talking about the people of the several states, has acquired any species of sovereignty as it as clearly asserts that they do lose it. So if the people of the several states are sovereign, then they're not sovereign if the federal government is sovereign or the states are sovereign. And here he is talking about spheres. By asserting that our political spheres are limited by their constitutional spheres of action, it admits that they are not invested with sovereignty. By investing them with the right of creating corporations as resulting from the power appertaining to sovereignty, it declares that they are. So Marshall was not only using Hamilton's version of the word necessary, meaning essentially convenient or useful or conducive to, but he was also saying that government is sovereign, and as part of its inherent sovereign power, in essence, that they could create this bank, and that's what made it necessary and proper. But Taylor then caught Marshall in really a basic logical error. You can't divide final authority. Final means final. If two people have final authority, that's just an impossible conflict. There can be only one. And he said sovereignty implies superiority and subordination. Hamilton, during the writing of the Federalist Papers, he basically said, this would, if one or the other. Otherwise, you're saying that the servant is greater than the master, and this is totally absurd. Anyways, Taylor continued, the word being rejected by our constitutions, sovereignty, cannot be correctly adopted for their construction. That's what Marshall did. So this term sovereignty, Marshall was saying, which government has sovereignty over this issue of the bank? And if the constitutions rejected sovereignty in government, then using sovereignty to define or to authorize government power is just totally wrong. It's incorrect. Because, he said, if this unanimous rejection arose from its unfitness for their design of defining and limiting powers, its interpolation by construction for the purpose of extending these same powers would be an evident inconsistency. Now, the framers were not being just merely academic about this. This wasn't just semantics to not include sovereignty in the constitutions. They understood that this word was poison to the Constitution, and it was poison to our rights. And that's how Taylor described it. Our constitutions, therefore, wisely rejected this indefinite word as a traitor of civil rights, traitorous to claim that government was sovereign or had final authority, and endeavored to kill it dead by specifications and restrictions of power, that it might never again be used in political disquisitions. Now, of course, they learned this firsthand. The founders, the old revolutionaries, they learned it firsthand that even good guys will become tyrants if you give them sovereignty or final authority, basically unlimited power to decide whether or not their power was enough. And that's how Taylor described things. By our constitutions, we rejected the errors upon which our forefathers had been wrecked, and withheld from our governments the keys of temporal and eternal rights, by usurping which their patriots had been converted into tyrants, and invested them only with powers to restrain internal wrongs and to resist foreign hostility, without designing to establish a sovereign power of robbing one citizen to enrich another. And that's ultimately the whole point, because governments love broad and vague terminology, because they can use them as weapons to expand their power over and over and over. And Taylor said, governments love obscurity better than specification. If a term is vague, and that's what the Anti-Federalists warned about over and over and over during the ratification debates, like even people like Brutus and Cato, they went basically to the level of saying, okay, the way that you're describing this power legally is probably right, but we understand that over time, this is a vague term, and people with power will always seek ways to expand their power by claiming that what they're doing is legal. And how do you do that? Well, it's much easier if you've got terms like necessary and proper or general welfare. General welfare, when Benjamin Franklin made his first draft of the Articles of Confederation, for example, in 1775, Thomas Jefferson had a copy of this and wrote some notes in the margin because the term general welfare was in there. He said, we should never have a term like that in a document so important. So the founders, the old revolutionaries, they'd certainly understood the problems with vague terms. And I think one side was probably just too confident of the legal definitions of those terms being understood over a period of time. But anyways, governments love obscurity better than specification. The unknown powers of sovereignty and supremacy may be relished because they tickle the mind with hopes and fears. And that brings us to the end game, which is the tyranny of unlimited power. Taylor totally understood the stakes of what was going on there in 1819, 1820, through these word games that twist the meaning of the Constitution. Well, again, once you allow them to do that for one thing, There's no limit to what they'll do it for in the future, whether they're going to have 1,000 new powers or 10,000 new implied powers. No one knows. He said that no sphere has a power of doing what is good or bad generally, but constitutionally only. And that if these principles can be overturned by an ingenious management of words, all our checks, balances, limitations, and divisions of power are good for nothing. If you want an 1820 version of the Constitution being treated as toilet paper, this is it right here. Because if they can change words, the meaning of words, ingenious management of words, checks and balances mean nothing. Limitations on power mean nothing. Words on paper mean nothing. Divisions of power, they're all good for nothing. And here's exactly how it happens. Taylor understood it was basically a step-by-step process. And it starts with that same trick that John Marshall and Alexander Hamilton used. He said, usurpation begins with weaving a shroud for free principles by the woof and warp of little conveniences and pretended necessities, and ends by inflicting the slavish quietism of a perfect subordination. And here's Taylor's prediction. I think this describes perfectly what we've been living under ever since. And he saw it all coming from John Marshall's opinion in 1819. Thus, he said, representative power may be made despotic. A coordinate sphere may be made supreme. Convenience, like the waves produced by a pebble thrown on smooth water, may be made to undulate indefinitely. A subordinate judicial power may start up into a dictator to the state governments. Divisions and limitations of power may be confounded and abolished. And here's the kicker. And English follies are converted from objects of our abhorrence into models for our imitation. That was the warning, and that was the prediction written over 200 years ago. Now, after hearing this, if you're feeling like John Taylor of Caroline called it, you're definitely not alone. But unfortunately, because of the government-run and government-approved so-called education system, we don't learn any of this stuff as we're growing up. We learn none of it. And that's a big part of the reason why we work so hard every single day here at the TAC to reach and teach more and more people with this essential, forgotten, and totally ignored history from the founders, from the old revolutionaries, and from the great thinkers that they read and learned from, about the Constitution and liberty and how to defend both when government refuses to do so, which is, 24/7, 365. And nothing helps us do this work more than the financial faith and support of our members. If you got a couple of bucks of that quickly devaluing dirty government fiat, please consider throwing it our way. 10thamendmentcenter.com/members. It's all spelled out, 10thamendmentcenter.com/members. Our membership program starts out at just $2 a month. We also have annual, 5-year, and lifetime options. I'd be incredibly grateful to any consideration you can give to joining us today. But if you don't want to become a member and you still want to help us out, pitch in financially, or if you're already a member, thank you. I can't say thank you enough, and you want to pitch in a little bit more, no pressure at all. I just want to make sure you have the link to do that, 10thamendmentcenter.com/donate. We don't just accept fiat. You could also send us some goldbacks, some Satoshis, whatever works best for you. We will put it to good use, reaching and teaching more and more people with this important stuff. And of course, there's a bunch of things that you can do that are free and easy peasy if you don't want to help us out financially or if you want to do even more. For example, hitting the like button, subscribing, getting notifications, reviews on Apple Podcasts or any other podcast platform, comments in the archive on YouTube and other video platforms. Watch time percentage is a huge thing for the algorithm. So a 10-minute video, watching 10 minutes is 100%. 30 minutes is 300% if my government education math. I usually use my phone for that stuff. But anyways, I appreciate any help you can give us, whether financial, otherwise, or combination. Thank you so much. Thank you so much for watching the show. I really hope you enjoyed this one. I hope it was interesting, maybe a little entertaining here and there, but more important than anything, I hope it made you think and I hope you learned something. Again, thank you so much for spending some of your time with me today. No show on Friday. I got some family visiting, so I'm taking a couple of days off, but I'll be back to my regular schedule next week, and I look forward to seeing you then on the path to liberty.